Good morning, sir. Are you Esker Boyin?
Yes.
And will your client waive the formal reading of the indictment?
No.
Mr. Boyin, in clause number 25, DCCR 0351, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault from March 5th of 2025. And how do you plead to that charge?
That's it.
Are you pleading no contest freely and voluntarily? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those documents on the computer, did you go over them with Mr. Parker?
I do.
And do you understand what you signed with him?
No, they care about mine.
Okay. Well, do you understand that if I follow this agreement that you've made, which is for a 2-year deferred probation, that you wouldn't be able to change your mind later? Okay. And you understand that the agreement that you've reached. So,
It's like criminal.
all right. Right. Understand, Mr. Parker? Okay. I understand. I need to make sure.
Explain judge that what problem the required probation, you have to report once a month, you have to find some food, there's no fine, there's just,
Here's the drama. Probation isn't free. It's high-stakes supervision. One missed meeting or failed test can land you straight back in jail. The judge resets the case with a doctor's visit to make sure Esker really gets it. Talk about extra layers of accountability. Eyes.
Probation is where you have a supervision officer to make sure you're doing everything you're supposed to be doing. Community. So here's what I'm going to do. I'm going to reset the case, Mr. Boyin. I'm going to have a doctor come visit with you to make sure you understand everything that's going on before we go forward, okay? So when they come out to the jail or visit with you online, you need to make sure and visit with them, answer all their questions. Yes, sir. I got to make sure. I got to make sure you understand everything that's going on. Okay. Okay. We're going to go back with the bailiff. We're going to make sure you can go back with the bailiff. Go ahead.
Boom. Paperwork deleted. This is a moment where the court is hitting pause, ensuring the defendant fully understands before moving forward. It's procedural rigor meeting real-life tension. Could this decision affect his future? Absolutely.
I'm going to delete that paperwork. Good morning. You're Antoine D. And Mr. Dill, you were previously in court and entered pleas of true to counts 1, 2, 3, 4, 5, and 6 in a motion to revoke your unadjudicated probation. On probation for the second-degree felony offense of burglary of a habitation, placed on probation. I think the dates in this updated report must be wrong. It says on May 8th, 2025, he met with the high needs officer for the initial visit. Should that be May 2024? Okay. All right. Just want to make sure. So, placed on probation back in April of 2024 for that offense. The allegations, failure to report, failure to work, testing positive, didn't do the theft prevention class, behind in fees, and behind in restitution. There was no agreement. Is that correct? Mr. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report? Any additions or corrections to that report? Okay. Thank you, ma'am. Go ahead, Mr. Lewis.
Yeah, big situation the problem with my client was some members of his family. He can't be one who gets tested with something. He sees you willing to get his way for gently try to prevent. I would also like to look in some better he was on any type of mental health, any type of condition still on his probation.
He was
I know it's
high
needs.
Mm-hmm.
So the trouble with him is Jefferson things he has gone through in his past that upset him or friendly to him. And I believe that, he's able to get that type of help. Help with that, I think that would definitely help with the second issue. I believe there are vehicles around the people that can address that more than one to accept that help. One understands the need. I know it was like the recommendation, it's subject to recommendations, to show ICO, something that we do recommend eat more than one fly with that and try to work with those as much as possible. If there is anything that's labeling that's sometimes we want to see or anything more than one. Definitely, I would stand for, only treatment he can for is, it would definitely help with some of the traumatic things he's going through in the past. It would definitely help with his, going forward.
Okay. The recommendation isn't necessarily ISF. It's if I were to continue, but the recommendation sounds like they've exhausted all efforts. Anyway, Ms. Mulfey now.
Overstep what the recommendation of the probation department is with respect to trying to help probation, but I read everything that's probably not
Well, it sounds like that's the recommendation of probation as well, really. Is that correct, ma'am? Yeah. I mean, sure, go ahead.
This is the heart of the emotional stakes. The defendant pleads for another chance, citing past failures and newfound motivation. But the judge lays it out bluntly. You've had 3 probation opportunities already, and probation only works if you actually comply. No sugarcoating. Collision.
But you begged me when you were here before.
I did not have a plan for my life. I started to get free. I never lived that team. And they really gave me a lot of inspiration, a lot of hope. God just saved my life. Thank you. Ms. Ford, I should have been my supervisor, and I apologize to Tracy. Frank, and that's the one who wants to work the way anything else.
Well, so here's the thing, Mr. Dill. When I looked back at your original pre-sentence report, there wasn't an agreement in that case. It was a cap. And the reason for that cap is because you already have felony criminal history. You've already had 2 felony probations that were both revoked. And then I gave you probation again because you stood there and did just what you're doing right now. You saying the words, you stop. You need to stop because things are not going to get any better. Okay? By what you can say. I appreciate that you probably would like to do what you're saying, but you've been given every opportunity. Probation's worked with you. Again, those felony probation revocations, one was in 19, one was in 2021. It's not like they were a long time ago. You've been given every opportunity on probations now 3 times. 3 times. And I mean, see, it worked with when I'm reading through the pre-sentence report. Ms. Core tried to contact you. She tried to reschedule. But that's probation for, to help you. You have to go to probation. You can't keep using those things as an excuse. All right, so I'm going to find that you entered your pleas true to counts 1 through 6 freely and voluntarily. Find those counts true. finds sufficient evidence to find you guilty, and at this time finds you guilty of burglary of a habitation. Going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I need you to sign that with Mr. Lewis. It shows that this was not an agreement, so you do have some limited rights to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Boyin. I understand this isn't what you want. Take advantage of it, and when you get out, take advantage of opportunities in the community, because there are some that can help you. All right? You can go back with it. I hope so. For you. Yeah, I hope so. I really, truly do. All right, sign that document. Yeah. All right, are you Victoria Bailey? And Ms. Bailey is 25 DCCR 0170, charged with assault on a public servant. And in 25 DCCR 0278, charged with assault on hospital personnel. And Ms. Bailey was evaluated for competency to stand trial by Dr. Antoine. I received that report dated April 22nd, 2025. Dr. Antoine makes the finding in each of these cases that Ms. Bailey is currently not competent to stand trial, and that inpatient treatment for competency restoration is warranted. Is there any other evidence?
And here's a twist: competency issues. The court orders inpatient treatment for up to 120 days to restore understanding. This isn't just bureaucracy. It's a legal safeguard to make sure defendants can participate meaningfully in their trial. Hospital balance scale.
Evidence with regard to competency, Mr. Parker?
No.
Mr. Nichols?
No.
Then at this time, based on that report, I am going to find Ms. Bailey not competent to stand trial, order that inpatient treatment for competency restoration be provided at the appropriate facility, and that to at that facility for a period of not to exceed 120 days from the date Ms. Bailey gets there, and we will await to hear if she has been restored at the end of that 120 days. You can go back with the bailiff. Well, they're going to send you to a hospital to get you some help to make sure you understand everything better. And so cooperate with everything they want you to do, and we'll get you back here and get your cases taken care of, okay?
So I'm going to hospital to do that.
Yeah.
120 days at hospital?
Well, it depends if you do what they say at the hospital and follow all the instructions, medication, whatever it is, so that you have a better understanding of everything that's going on. Okay?
I don't need this to do that.
You can go back with the bailiff.
I don't get it. Why not they get to jail? What does that mean?